Thank you, Mr. Mayor. I was contacted today by Derek Moss of Kingston DCH, who is the individual who took the council to court regarding their LAAA obligations. He has no right to speak this evening. As a representative of residents in the borough, I was asked to raise concerns on his behalf, and I'm only too willing to do so. I've condensed his rather lengthy letter to all councillors to try and fit in with the time limit allowed on this item to convey his concerns. Mr. Moss says, "The report has been produced after I wrote to the monitoring officer on 24th of February 2022 about the council's unlawful refusals to comply with my requests to inspect the accounting records and related documents pursuant to Section 26 of LAAA, which explicitly includes contracts for 3 years running, 2019 to 2021. Paragraph 7 of the report, which you can find in Appendix D, it says, quote, the council sought to apply a proportionality reasonableness test, determining it was entitled to rationally conclude that the request was disproportionate or manifestly unreasonable. That is untrue. On the 9th of July 2019, an officer wrote to me stating while she recognised there's no time limit exception in LAAA, she believed there should be, so she decided to rely on the 18-hour time limit that applies to FOI requests to refuse to comply with my LAAA request, which is unlawful as the administrative court found in April 2021. The officer didn't say anything about applying a proportionality reasonableness test or concluding my request was disproportionate or manifestly unreasonable. The court also found that complying with my request by providing the contracts I've requested would have not placed an unreasonable burden on the council, and the burden that it did place was, quote, a necessary consequence of maintaining the long-standing public right to scrutinise the accounts of a local authority. And the court concluded that the council acted unlawfully by refusing my request based on the time it would take to comply with it. By referring to FOI requests, the report ignores the fact the court rejected the council's argument that the inspection rights under LAAA and FOI are similar and found that the wide-ranging Section 26 right to inspect a local authority's accounts, a right of which has existed since the Poor Law Amendment Act 1844, is quite different from and serves a different purpose than the more limited freestanding general right of access to information at any time, which only came into existence when the Freedom of Information Act was enacted in 2000. Paragraph 21 of the report says my application to seek judicial review of the 2021 decision, quote, is not based on a decision not to provide the requested information, but for failing to have fully processed the request within the 30-day inspection period. That is untrue. My pending judicial review is based on the council's unlawful refusal to comply with my Section 26 request within the 30-day inspection period, which prevented me exercising my Section 27 rights.
1 minute.
This was the same basis for my 2019-2020 reviews, but this time the breach is aggravated as it occurred 5 months after the court confirmed residents have a right under Section 26 to inspect the contracts and the council has a duty to make them available. Finally, the report doesn't mention how much the council's non-compliance cost taxpayers. A full copy of Mr Moss's evidence and findings can be found on the Kingston DCH website, and I would encourage members and residents to read the article and evidence in full. I found it interesting reading. It only came to my knowledge today, but I will be following some of it up after the meeting, and I would urge other members to do the same. And I'd finally urge the council not to waste money defending ridiculous claims. This isn't the first time the authority has done so. It did so against the New Malden Farmers Market previously. And I personally think money is far better spent providing residents with good services than it is defending egregiously defending legal cases.
Thank you, Giles. As I said to you, I just wanted to say again, no action is required at this meeting, but is there any other member? I think Councillor, Leader of the Council, Councillor Kirsch, would like to say something.
Thank you, Mr. Mayor. I just wanted to highlight, as this report deliberately does not name any person, just to please take that into account. So any drawing of conclusions who was mentioned in what capacity in this report, I think is not the best way to take this forward. The issues you have mentioned from what you quoted are dealt with in this report. I just wanted to highlight that again. Thank you, Mr. Mayor.
Point of personal explanation, Mr. Mayor.
Who?
Point of personal explanation. Whilst I recognise the report doesn't name any individual, I had permission from the named individual to raise his concerns this evening, which is why I did so, albeit condensed, but verbatim as given to me.
So you want to say something, Kirsch? Please, Councillor Kirsch.
Yeah. Thank you, Mr. Mayor. Councillor Giles, I didn't in any way question if you had the permission or not. What I wanted to say is that this report deliberately didn't mention any individual, and that I, in the role as leader of the council, and we as council noting the report, would like to highlight that the report does not want to go into personalities. That is, the report gives a clear evidence of what on the duties the council has to report on, and deliberately it's not involving any individuals. I just wanted to say this is, we should detach the report from any individuals and what individuals think, or however they are involved or not. I think it's not something which we should debate or not debate in this chamber at this moment in time. Just wanted to clarify this. This report protects any individuals. If individuals want to come forward, it's up to them. And if individuals want to address these issues, they have time to raise all these issues in other council meetings. This is many of these things are ongoing issues for a longer time. Documents are for a long time in the public sphere. So just wanted to highlight the distinction.
Once again, thank you. So it's all been noted. I'm sorry. So having received the report, we now move to the next item. Can I allow her to speak? Yeah, Councillor Bass, please.
It's just a question really on this one. It's quite a simple question. It's just I wondered why this didn't go as information to councillors and why it was tabled at full council. Because obviously by having it at full council, it's obviously created this sort of debate, but I just wondered why it wasn't just information to council, because there's no action on it, why it came as a paper to full council.
Thank you, Mr. Mayor, and thanks, Councillor Boss, for the question. As the law demands us to report these issues highlighted in the report to full council, hence not, to make it also public aware and on record. If it would be an email to all councillors, it would not satisfy the law.
So that, moving on to the next item, this is just noted, yes? It's all there. Thank you for your comments.